You sued your doctor for medical malpractice, claiming that he was careless and that his carelessness was a cause of your injury. During the course of your lawsuit, the defense actually makes you a settlement offer that you think is pretty fair. Before you have a chance to say yes, the defense actually backs out of their offer and says, screw that, we'll see you at trial. Can they do that? Does that really happen? You want to know the answer? Come join me for a moment as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is, it does happen, but it's extremely rare for it to happen. Let me tell you why. If the defense has finally turned around after years of litigation, or at some point during the course of your lawsuit, and says, listen, we've evaluated the case, we think the case should be settled, we don't want to go to trial, and now they make you a settlement offer. You and your attorney believe that this settlement offer is appropriate, and you think it's a good number that they're offering, and there are no conditions associated with this particular settlement offer. And now, before you and your attorney have a chance to respond formally to this offer, the defense attorney calls your lawyer and says, hey, remember that offer we spoke about last week? Well, guess what? Because you and your client did not get back to us within a certain period of time, that offer is now off the table. And your attorney starts saying, what are you talking about? How could you take such an offer off the table? You didn't tell me there was a time limit. And now the defense attorney is backtracking. He's saying, doesn't matter. The offer is now off. The insurance company has given me very specific instructions. They told me to pull out of the offer, and now, what do they want me to do? They want me to go ahead and take the case to trial. So, that's exactly what we're going to do. And now your attorney calls you up to tell you the bad news. And now you're as shocked as he is. I don't understand. How could they back out of an offer? How is this possible that they can make a good faith settlement offer, and now, a week later, turn around and say, hey, this offer is no longer on the table? Can they do that? The answer is yes, they can, but it's really negotiating in bad faith. Unless the defense attorney has put a strict time limit on when we have to reply to their offer, guess what? The defense should not be pulling out their offer. Once the defense makes a settlement offer, I am obligated to contact you, the injured patient, to tell you and let you know about the settlement offer. And then we have to discuss it. I have to tell you about the pros and cons, the risks associated with either accepting it or not accepting it. Based upon that discussion, you, the injured patient, will now have the ultimate decision about whether or not to accept it or to try and counteroffer whatever it is that they've offered to you at this point. The example I raised in this particular video is the defense has made a good faith settlement offer. Now you and I have talked about it, but before we've had a chance to reach a decision and get back to the defense, they have already withdrawn their offer. So to answer the question, can they do that? Yes, they can. Is it good form? Is it good faith? The answer is no, it's not. Because now we're going to have a bad feeling in our stomach, and now you, the injured patient, are much more likely to go to trial and take a verdict. Why? Because they've offended you. Because now they've offended your sensibilities. Because now you know that they are not negotiating in good faith, and now there's no point in talking to them any further. So any attempt at further settlement negotiations are clearly not going to happen, and now you're going to let a jury make an ultimate decision about whether or not you are slightly more likely right than wrong, that what the doctor did was careless, and that his carelessness was a cause of your injury. So why do I share this with you? I share this with you just to give you a sense of what does happen occasionally in these medical malpractice cases, these accident cases, and even these wrongful death cases here in New York. You know, I do understand you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.